I can.
Great, thank you. Kind of scanning the tiles, and it appears to me that everyone is here who I think I expected to be here. I don't recall. I don't think the office participated in the scheduling conference. Any indication whether the office is going to participate in this hearing today?
I don't believe they are.
Okay, I figured as much, but I just, my mind doesn't work the way it used to. Okay, well, why don't we get going here? So good afternoon, everybody. My name is John Delaney, and I'm the Commission's designated presiding officer for this future virtual hearing. Today is November 20th, 2025, and it's approximately 1 p.m., and this is the date and time that's been scheduled for the virtual hearing in docket number 25-057-23, which is the application of Enbridge Gas Utah to change the infrastructure rate adjustment. Okay, why don't we start with appearances? Ms. Clark?
Yeah, this is Jennifer Clark, and I am here with Tyson Louder, who will be the witness for the company.
Thank you very much, and good afternoon, Mr. Louder. And for the division, please. And for the division?
Patrick Grieco, Assistant Attorney General, representing the division. The division's witness this afternoon will be Eric Orton.
Good afternoon, Mr. Orton. Okay, I have a couple of preliminary matters as usual, and let me start with them because this one is new. So we're doing something a little bit different with respect to recording this proceeding. What we're going to do is we don't have a court reporter with us, but we're recording. Pardon me, sorry you had to hear that. We're going to record this proceeding via Zoom, and then this recording will be of both the audio and the video. And that recording will be submitted to a third-party transcription service, which will complete the transcription of this proceeding, certifying that it's a true and accurate transcription. So we're not going to have anybody as a third party today interrupting us when we speak too softly or too quickly. Because of that, please, everybody, take it upon yourself to because we're trying to get a clear record here, to speak clearly, speak at the appropriate pace, and please speak directly into the microphone so that the recording is viable. Also, please mute yourself when you're not testifying or otherwise speaking. Any questions? Okay, I have a request. Tyson and E. Orton, please change your names to your full names. So Tyson Louder would be your full name, and E. Orton would be Eric Orton. If you don't know how to do that, my understanding is Tyson does. Mr. Louder does. Eric, if you hover over your own tile and you click on the right hand, oh, wait. Sorry, somebody else is going to have to, I guess I don't know how to do it with Zoom.
No, that's right.
Okay.
Sorry, looks like it's working. Just a sec.
Okay, there we have it, Eric Orton. This
Thanks
way,
for coaching.
Yeah, everybody is fully represented by name and then their voice, and the transcription should be more accurate. Okay, another thing is I want to note that we didn't receive any reply comments from EGU in this docket. I want to make sure we didn't miss anything. Is that accurate that EGU did not file reply comments? You're muted.
I apologize. Mr. Louder and I are sharing audio, so you don't get an echo. But we could not hear what you were saying. But I'm going to infer from the first two words that I heard that you did not receive reply comments. That was intentional.
Right.
And Mr. Louder will, well, to give you a preview, the company agreed with the division's comments, and Mr. Louder will so indicate during his testimony.
Wonderful. Great. Thank you very much. I just wanted to make sure we didn't miss anything. All right. Before we get going in earnest,
And we're still not hearing you, sir.
Mr. Greeku, are you hearing me?
I can hear you great.
Ms. Clark, could you hear Mr.
One moment, please.
Oh, okay.
All right. I think we've fixed the problem on our end. Let's see if we can hear you now.
Test 1, 2, 3.
We can hear you. Great.
Okay, there's an echo now. Wait, there's not. Great. All right, wonderful. Any preliminary matters from the parties? No, I see one.
None from the company.
Okay, wonderful. Why don't we get going then? Ms. Clark, if you would like to call your first witness.
The company calls Tyson Louder.
Good afternoon again, Mr. Louder.
Good afternoon.
Do you swear to tell the truth today?
I do.
Okay, you're sworn. Please proceed, Ms. Clark.
Mr. Louder, can you please state your name and business address for the record?
Yes, it's Tyson Louder, and my business address is 333 South State Street in Salt Lake City, Utah.
Mr. Louder, what position do you hold with the company?
I am a regulatory analyst.
And Mr. Louder, did you prepare or cause to be prepared the application that was filed in this matter, along with the accompanying exhibits, EGU Exhibit 1.1 through 1.6?
I did.
And do you have any corrections to any of those documents?
I do not.
Do you adopt their contents as part of your testimony today?
I do.
The company moves for the admission of the application and accompanying exhibits 1.1 through 1.6.
Thank you very much. Any objection to the motion, Mr. Greeku?
No objection.
Okay, your motion's granted. It's admitted.
Thank you. Mr. Louder, can you please summarize the relief the company seeks in this matter?
Absolutely. In this docket, the company seeks to adjust the infrastructure tracker replacement rate to include investment related to replacement projects that were in service as of October 31st, 2025. The company is requesting $2,398,474 in annual revenue related to this investment. If approved, this would result in an increase of $1.12 or 0.017% per year paid by a typical customer using 70 decatherms per year. To be clear, the requested rates will only remain in effect for 1 month until the new base rates take effect in the pending Utah general rate case. In January 2026. The infrastructure rates will be set to 0 and no revenue will be collected through this mechanism until incremental investment exceeds the threshold proposed in the general rate case. Because this can be confusing, I would like to walk through the mechanics of this process. When the company filed its general rate case in docket 25-057-06, it included actual capital spend through 2024 for all projects included in the tracker program. The company also forecasted total capital spend in 2025 and 2026. This forecast included the assets in the tracker program and is part of the total revenue requirement in the 2026 test period in the general rate case. The total 2025 and 2026 capital included in the general rate case test period for tracker project was $96 million. On January 1st, 2026, the forecasted $96 million of investment will be included in the new base rates as part of the general rate case. Also on January 1st of 2026, the tracker rate will be set to 0 because all infrastructure replacement investment will be included in the new base rates. The company will continue to invest in infrastructure replacement, but will not file a tracker application for revenue recovery until its investment in those projects exceeds the amount included in the general rate case. That capital spend from 2025 forward will be subject to future review in tracker proceedings. So as I mentioned earlier in my summary, these proposed rates will only be effective until January 1st, 2026, when the rate case takes effect and no cost will be included twice in any particular rate simultaneously. On November 12th, 2025, the Division of Public Utilities filed comments in this docket. The company agrees with those comments and the proposed rates are just, reasonable, in the public interest. The company requests these rates be approved on an interim basis with an effective date of December 1st, 2025. This concludes my summary.
Mr. Louder is now available for cross-examination and the hearing officer's questions.
Thank you very much. Mr. Riccio, do you have any questions for Mr. Louder?
Thank you. No questions.
Okay, Mr. Louder, thank you for that tutorial on the otherwise complicated but straightforward, based on your presentation, explanation of this issue of timing. I did have a bunch of questions for you on that, but I don't now. I just want to get clear two things actually. You have seen, obviously, based on your testimony, the comments of the division dated November 12th, 2025, correct?
Correct.
Okay. That the division takes the position that they're a little more direct about the 1 month that this will be in effect. And it, in the comments, says December of 20, it says December, and I'm adding 2025. Do you agree with that?
Yes, we do.
Okay, then I'm going to walk you through this. So then by my math, the proposed annual increase of $1.12 per year divided by 12 months equals 0.093 cents per month. Do you agree with that?
Correct, yeah.
Okay, so thus the net effect of what this application seeks is an increase of 0.093 cents for only 1 month, correct?
Correct.
Okay, great. Thank you. I have no further questions for you.
Thank you.
Okay.
The company has nothing further. Thank you.
Okay, great. Why don't we jump over to the division? Mr. Griecu, if you'd like to call your witness.
Thank you. The division calls Eric Orton.
Good afternoon again, Mr. Orton.
Good afternoon.
Do you swear to tell the truth today?
Yes, I do.
Okay, you're sworn. Please proceed, Mr. Griecu.
Thank you. Mr. Orton, could you please state and spell your name for the record?
My name is Eric Orton. That's ERICORTON.
And by whom are you employed, and what is your position?
I'm employed by the Utah Division of Public Utilities. I'm a utility technical consultant.
And what is your business address?
160 East, 300 South in Salt Lake City.
And can you provide a very brief overview of your educational background and relevant work experience?
Sure. I have an MBA degree, and I've been in utility rate making and regulation in Utah for over 27 years, dealing mainly with Enbridge and its predecessors and ancillary companies.
And have you participated in this docket on behalf of the division?
I have.
And did you review and evaluate the company's application in this matter?
That's right.
Did you prepare and cause to be filed or participate in the preparation and filing of the division's comments filed on November 12th, 2025?
Yes.
Do you have any changes or corrections to that filing?
No, I believe it's accurate.
And do you adopt the contents of that filing as part of your testimony today?
Yes.
And based on your review, would approval of the company's application on an interim basis be just, reasonable, and in the public interest?
It would.
I'd like to move to admit the division's comments filed on November 12th, 2025.
Thank you. Ms. Clark, any objection to the motion?
No objection. Thank you.
Okay, your motion is granted. The comments are admitted.
Thank you. Mr. Orton, do you have a summary to share today?
I do.
Please proceed.
Thank you. Based on the division's preliminary review of the application, the division recommends the commission approve the proposed rates in this infrastructure rate adjustment as requested by Enbridge on an interim basis with an effective date of December 1st, 2025. The purpose of this filing is for Enbridge to seek to modify the infrastructure rate adjustment tracker to the distribution non-gas cost portion of its Utah natural gas tariff, section 2.07. The current proposal recommends a revenue requirement increase of $2,398,474 on an annual basis. This application complies with past commission orders, and the division recommends the commission approve the proposed rates on an interim basis until the division can complete its audit, at which time, if it finds reason to recommend an adjustment, it would do so to the commission and recommend any imprudently incurred costs be deducted. That concludes my summary. Thank you.
Thank you. The witness is available for questions from the company and from the hearing officer.
Thank you very much. Ms. Clark, any questions for Mr. Orton?
No questions. Thank you.
Okay, thank you. Mr. Orton, I do have a couple of questions for you.
Great.
You were here and heard Mr. Louder's testimony, correct?
That's correct.
Is there anything that you disagreed with respect to Mr. Louder's testimony?
No, there wasn't.
Great. Do you have the DPU's initial comments?
I have them here. Yes.
Okay. This isn't substantive, but it's procedurally substantive from my perspective. So I want to ask you a question about the last sentence in the second paragraph under the caption background. It's on page 2. Pardon me.
Thank you.
Sure.
I'm ready.
Okay. So, quote, as a result of the commission's scheduling order, initial comments became due on November 12th, 2025. Do you see that?
Yes, sir.
Okay. I guess I want to ask you a question because I interpreted that. There's a couple of different ways I can interpret that. One of the ways I interpreted it was that it's possible that the period of time from which the scheduling conference was held and when the comments were due was somewhat truncated, or the period within which DPU had to provide its initial comments was rushed. So I want to ask you, what was that amount of time between the scheduling conference and the deadline for DPU's initial comments truncated, overly truncated?
It was not overly truncated, but it was truncated. We put in extra time during those few days in an effort to give the commission sufficient time to have an order out, given the holidays next week by December 1st. So yes, it was rushed. It was not overly rushed such that we don't feel we did an adequate job.
Okay, because I want to avoid the division or any party feeling unreasonably rushed. The nature of some of these applications, unfortunately, and things like holidays and weekends doesn't give us the luxury of overly long amount of time. And I want to avoid this in the future, but you know, I got to start here. You guys agreed to this proposed schedule.
We did.
And your agreement is what's reflected in the scheduling order. So given that, what is it that we can do, the commission can do to help alleviate a sense of being rushed in, I guess, meeting the obligation that you agreed to in the first instance? I mean, what is it that we can do, if anything?
That may be the most difficult question I think I've been asked over all these years.
Okay.
It is, from our perspective, it is critical that we're given the time we need to do a sufficient job to investigate these applications. This application was not a complicated one. So with the extra time that we spent in those few days, it was sufficient. However, we do not intend to make this a precedent by any means, and we generally will take all the time that we can according to statute to fulfill our duties and provide the information that the commission needs. So I don't have any specifics. Thank you.
Okay, then I guess my takeaway would be this. There's nothing you said I disagree with, especially with respect to what your obligations are. And as that translates to time, I'm not you, so I don't know what the amount of time is. And I think Enbridge also expects you to have enough time to do a reasonably thorough investigation and draw some conclusions. So I guess at the end of the day, what I'm going to suggest is that perhaps a little bit more time and consideration needs to be devoted to what it is you're committing to in the first instance as an agreed to schedule that then gets in front of us. Because I'll tell you, ultimately, we too have concerns on our end because we have deadlines that we're trying to meet, and we have workflow issues within our office too. But in the first instance, if it's as good as it's going to get from the parties, we rely on that as a commission to defer to the parties and their ability to come up with an agreement. And if it does conflict with something going on here, I think you've experienced this with me before. I'm not too shy to tell you, and then put our heads together to see if we can work it out. So I'm glad I raised this issue. Although I had to kind of divine it because it wasn't very directly stated. And so I'm glad I decided to address this issue. That's my 2 cents is let's just stay the course and try to make sure everybody agrees in advance. Whatever everybody agrees to in advance actually is something that they can live with to fulfill their respective obligations.
Thank you.
Okay, I don't have any other questions. Is there anything else we need to address with respect to this docket?
Nothing from the company.
Nothing from the division.
Okay, thanks, everybody. We will be adjourned and have a nice weekend.
Thank you.
Take care.